Item number 22, listed in court number 7 also. Physical appearance of district account officer आज था also. Court number 7 आज stand over है. Therefore also काम mentioning.
Who has come? With the name and the designation.
Also district account officer also.
लिख के दीजिए. नाम और पूरा डिटेल. फाइल का है इसका. फाइल. ऐसे सर्कमस्टांसेस में तो आरजी के पास जाके आप
डॉक्टर हम गए थे, सुबह ही गए थे.
हाँ.
तो वहाँ पे भी आरजी साहब थे नहीं, तो बोले कि आप बिफोर ऑनरेबल कोर्ट आप मेंशन करिए. तो इसलिए फिर हम सुबह मेंशन नहीं कर पाए थे, लेट हो गया था.
फाइल मंगा लीजिए.
From supplementary list or final list was item 1, WPL 7795 or 2112.
Appearance of maybe depending.
Yesterday I have already recorded the submissions of both the parties in great details. I'll just reserve the judgment and post for judgment on Monday. I've not been able to do the needful. Right. So the counsel for the parties are present. The argument of the respective parties has already been recorded by order dated 21/11/2024. Let this matter be posted for judgment on Monday.
For this item 2, WPL
Mr. Mishra, the matter will come up on Monday for judgment straight away. Right? I couldn't do the needful I couldn't give the dictation in my chamber. You get the judgment on Monday. It will be pronounced in the court. Okay.
For this item 2, WPL 2959 of 2018.
What is this for?
The order was also passed on the 28th and 2024.
Oh, the date is error. There is an error in the date. Okay. The matter has been placed at the instance of the office. It has been reported that the date of disposal of the case has been mentioned as 28/10/2024 instead of what should be the correct date? 29 instead of 29/10/2024. Peruse the records. There appears to be a typographical error. Consequently, the date of order, the date of disposal of the petition being WPL number 2959 of 2018 as recorded in the final order is modified and is directed to be read as 29/10/2024. The date of disposal has been mentioned in the first page of the order. Office is directed to carry out the necessary correction in the final judgment. हो जाएगा इससे? हाँ, same चीज़. वो 3 एक साथ हुआ था। ये करवाइएगा उनसे जिनका ऑर्डर, ठीक है?
From daily list
एक बार राकेश जी को दिया, कौन किसका है ऑर्डर? मुकुल, एक बार दिला ही दीजिए।
for final disposal from daily list item 1, the LPL 3402 of 2013. Item 2, second appeal 110 of 2017.
Nobody appears on behalf of the parties. Post on 10th of January.
For orders, item 4, WPC was 4475 of 2016.
डेट्स सर्टिफिकेट पेंडिंग है, इलेक्शन में दिया गया है, तो टाइम चाहिए, इलेक्शन के साथ जा नहीं पाएगा।
इसका डेट
पीटी नंबर पिटिशनर नंबर 3 लेडी।
counsel for the petition seeks a judgment. Post on 10th of January. इसमें देखिएगा कुछ मैटर है, कुछ के इस पे केस DUT है 1 to 19 restored तीनों ऑर्डर मॉडिफाई किए हैं क्योंकि आपका ऑर्डर है, आप ही उसको बनाएंगे, उनको डिक्टेशन दिए बना ही देंगे, फिर यू विल करेक्ट इट अकॉर्डिंगली।
CV review 135 of 2019.
My lord's counter has been filed. I had ordered to file rejoinder, but due to inadvertence, I could not file. I'm requesting for a short accommodation to file the same. Order was also to file the rejoinder to the counter.
Counsel for the petitioner seeks a judgment to file rejoinder to the
Counter affidavit.
counter affidavit in relation to IA number 7169/20. Post on 10th January. 10 January.
सेकेंड वीक ऑफ दिसंबर में जस्ट
13 January.
Already.
13 December.
13 जनवरी
13 10 जनवरी को परेशानी 10 जनवरी
Item 6, CMP 188 of 2022.
Nobody appears on behalf of the parties. Post on 14th of February.
Item 6.
आप हैं? क्या है? Right?
नोटिस इशू हो गया था लेकिन रिटर्न आ गया कुछ रेस्पोंडेंट का क्योंकि वो लोग मर चुके हैं।
किसका रिटर्न है?
रेस्पोंडेंट नंबर 7, 10, 11, 12, 13 and 14
7, 10, 11, 12, 13,
and 14
14, 7, 10. इन सब पर डेथ हो गए
हाँ
तो क्या करते हैं?
सब रिटर्न पिटीशन फाइल करने के लिए 4 वीक टाइम
CAP number 188 of 2022. Counsel for the petitioner seeks adjournment to take appropriate steps in connection with deceased respondent number 7, 10, 11, 12, 13 and 14. We submit that the notices sent by the order of this court has returned unserved, showing that they have expired. That idea.
4
Post this case on 10th January under the heading for this. सबका डेथ हो गया, आपको पता ही नहीं है कि सबका डेथ। So far as the respondent number 6 and 9 are concerned, the notice is accepted as valid in view of laws.
But I'm reading serial.
Respondent comes. जाइए respondent को आप थे नहीं तो डेट हो गया।
Item 7, CMP 1024 of 2023.
In this case, notices were issued to the opposite parties. According to office note of the respondent number 2 and 9 have died. Like 3 weeks time to filing substitution to different laws.
And what about others?
So far, the other opposite party 3 has validly served and notice of respondent number 4 received by his brother and 5, 6, 7 could not be served. And 8 lots he received by his son.
So 1, 3 and 4 may be accepted as valid. 8 also.
8 also.
The learned counsel for the petitioner submits that as per the office note, OP number 1 and 8 are same लिखा है 1 and 8 and OP number 2 and 9 are also the same.
एक का substitution
2 and 9 are one and the same लिखा हुआ है इसमें. 2 and 9 same है क्या? नाइन को फिर चोखा है ही जी तो लिखे हैं.
मेरे में तो 9 1 over 10
नहीं इसमें है ना 1 and 10 1 2
एक का डिलीट करने के लिए हम आईए पिटीशन फाइल करते हैं. अगर सेम पर्सन है तो एक का
नहीं
डिलीट.
आप ऑफिस नोट भी ठीक से नहीं देखते हैं तो क्या ही हम देखें. अब देखिए ऑफिस नोट देखिए बोलते हैं कि सेम आदमी को दो दो बार पार्टी बना दी और वो दोनों का आ गया रिपोर्ट पे डेड. तो डेड हुआ है एक आदमी और दो का रिपोर्ट आ गया. देखिए
गलती से लगता है 2 आदमी को बन गया.
आप देखिए ना ऐसे गलती से बोलने से ऑर्डर नहीं होता गलती से.
Item 8 CMP 912 of 2024.
नोटिस सब हुआ था लेकिन वो रिटर्न हो गया क्योंकि दोनों रेस्पोंडेंट ने जो एड्रेस चेंज कर चुके हैं और न्यू एड्रेस लोकेट नहीं हो रहा. उनसे कोई कांटेक्ट भी नहीं हो पा रहा है.
CSP नंबर किससे कांटेक्ट में था?
दोनों रेस्पोंडेंट्स के मोबाइल नंबर भी उनका बंद है.
कौन रेस्पोंडेंट है दोनों 1 and 2?
1 and 2 both are sister. ये रिस्टोरेशन में फाइल किया था और जो मेन पिटीशन है वो भी अब तक नोटिस में नहीं गया था.
मेन पिटीशन क्या था?
MA 172 MA 172 of 2023. Actually that was delayed due to 1 day of cook. That's why I filed CMP. And CMP also returned and served.
लिमिटेशन है ना. रेस्टोरेशन में लिमिटेशन लगेगा तो बिना नोटिस के हम लोग नहीं कर सकते.
तो उससे कभी नया एड्रेस तो लोकेट नहीं हो पा रहा.
CMP number 912 of 2024. Then it comes for the petition submits that notice was issued to respond number 1 and 2. But the same has returned unserved, showing that the door was found locked and party was out of station. ऐसा तो नहीं है लेफ्ट बोल के तो कोई नोटिस ऐसा नहीं है. The door was found locked.
नेबर से पता किया तो वो लोग काफ़ी टाइम से वहाँ नहीं रहे. बहुत दिन पहले ही छोड़ चुके हैं और रिलोकेट कर चुके हैं.
The learned counsel for the petitioner seeks adjournment to find out the whereabouts of respondent number 1 and 2, or to take appropriate steps in the present case. How much time do you need?
4 weeks.
Appropriate steps regarding substituted service of notice upon respondent number 1 and 2. Substituted service से हो जाएगा काम आपका. Door was found locked. It is not, the office note does not say that they were not there. ऐसे लिखे the counsel for the petitioner. In view of the office note, the counsel for the petitioner prays for time to find the whereabouts of the respondent number 1 and 2. Post on 10th January. उस दिन आपको वो अपना पिटीशन फाइल कर देंगे सब्स्टिट्यूटेड सर्विस और
While admission at 9 WPS 568 of 2014.
Who is for the petition? Why is this WPS matter has been listed over there? What is the basic ground?
That no particular evidence has been produced before the disciplinary committee
No particular
regarding
evidence.
irregularities.
इसका तो ऑर्डर हम लोग किए हुए हैं दूसरा केस में.
The
Then क्या
dismissal
नाम?
order.
हाँ?
The allegation was that the petitioner has malpracticed and
मनरेगा.
misappropriated the fund allotted in the Manrega scheme. Annexure 5, page 77, the dismissal order.
Also for the petitioner seeks adjournment by submitting that the RBI council is on legs in another court. Post on next Friday. In the meantime, prior to the next date, the council for the petitioner shall submit list of dates and synopsis of arguments and also the judgments which he seeks to deny. State is not there. Nobody appears on behalf of the state. बना देंगे एक notes. अगला दिन में date time रखना होगा. Counter entries are complete है ना?
Also, case item 7 CMP 1024 of 2023.
It is correct also opposite party number 1 and at 8 are same person also I will file appropriate application. So far is opposite
You
party
can
number
delete
2.
it.
Yes, I may be permitted to delete. Opposite party number 2 and are not some the same person lordship. One है छोटा आई है, दूसरा है छोटा आई है.
पिताजी का नाम सही है. Both sons of पिताजी का नाम तो सेम है.
Same.
तो एक
हम
छोटा है एक छोटा
डिलीट कर देते हैं स्पेलिंग मिस्टेक इसमें कुछ हो गया दोनों को हम एक का जो है
डिलीट करेंगे आप.
डिलीट कर देते हैं
आप पिटीशन फाइल करते
हम पिटीशन फाइल कर देते हैं
दोनों में से कौन सा सही है कहना
हम उसी
मुश्किल.
में एक्सप्लेन कर देंगे आइए पिटीशन
Counsel for the petitioner seeks adjournment. He submits that interrogatory application is required to be filed to delete the name of the persons whose name appeared twice amongst the list of the respondents,
yours opposite party
opposite parties. Post on 10 January.
Password case item 1 WPL 3402 of 2013.
Sorry, this case personal defect to my senior GM is some medical problem. 29 one any date.
मेडिकल प्रॉब्लम है. अभी तो ऑनलाइन बहस है.
कुछ गले में प्रॉब्लम.
कल इतना अच्छे से बहस किए अभी ओवरनाइट.
नहीं
अरे भाई कुछ सोच समझ के बोला करिए. एक केस के लिए he was attending the court.
यस
Then
एक्सेप्ट कर नहीं बोले हाँ कि नहीं कुछ प्रॉब्लम
क्या ही हम आपको बोले. कल इतना देर वो बहस किए हैं और आज भी ज्वाइन किए.
यस एक्सेप्ट कर इसलिए 29 इसलिए सीनियर से भी हम रिक्वेस्ट
इसीलिए पता है एडजर्नमेंट के लिए कॉस्ट वॉस्ट लगाने से ठीक रहते हैं, तो ऐसे इतना कैजुअली टाइम मांगते हैं। अब क्या ही बोले बताइए, सीनियर काउंसिल खड़े हैं तो हम उनको क्या बोले, आपका केस नहीं सुनेंगे।
सीनियर काउंसिल से रिक्वेस्ट ले ली
उनसे कंसर्न ले चुके हैं,
Consent ले
I
तो
have
फिर आप
not
किस लिए आए हैं?
I have not objected on the ground of illness. Well, that's
Why have you come? Your junior could have been there.
I was ready to argue, but when my learned friend informed that he had requested on the ground of illness, I could not have refused.
The learned counsel for the parties are present. Counsel for the respondent, Mr. J. Upadhyay,
GN
G.N. Upadhyay, submits that the matter has to be argued by Mr. G.N. Mishra, who is unbailed. Counsel for the petitioner has no objection to the prayer for adjournment. बताइए कब करना है?
29 के बाद एनी डेट
29 के बाद, 29 तक वो बीमार रहने वाले हैं। Post this case, final disposal में है।
हाँ जी।
Post on 6th, the consent of the council for that.
छः और 15 कर दिया जाए क्योंकि 6 को और सब मैटर ऑलरेडी फिक्स्ड है चीफ रिपोर्ट में, इसीलिए सो दैट
जब केस टेकअप होता है तब अपना कंसेंट से टाइम मांगते हैं, उस समय देखेंगे जब केस फॉलो आउट होगा।
हाँ थोड़ा सा एकोमोडेशन तब चाहेंगे।
आपको कभी एकोमोडेशन मना किए हैं मिस्टर सिंह?
नहीं, फिर भी कहने से कहा पहले का 6 को ठीक किया, कुछ मैटर फिक्स्ड है इसीलिए।
तो 215 में फिर आपको भी दिक्कत हो जाएगा ना। मान लीजिए और सेकेंड हाफ में मैटर स्पिल ओवर हो जाए तो 6 तारीख को नहीं रखते हैं, 13 तारीख को रखते हैं।
6 को बड़ा एक हाँ एक ऐसा मैटर फिक्स्ड है लॉर्डशिप कहीं पर नहीं, मतलब दैट इज ए डिस्प्यूट रिगार्डिंग द चार्जिंग ऑफ द चैम्बर्स लाइसेंस फी एंड दैट हैज बीन
वो भी आप लोगों ने चैलेंज किया है क्या?
that was already challenged. That in that case, I have also intervened. So that matter is fixed, and now the matter has gone from court number 6 to Chief Justice's court. So that's why Millard I.
नहीं तो दूसरा डेट दे देते हैं,
हाँ दूसरा डेट
13 को दे देते हैं।
हाँ ठीक
वो तो हैप्पी विद दैट डेट
हाँ।
लेके कितना खुश हम देखें
नहीं
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 आ सकते।
नहीं हम I am ready to argue and I want that the matter should be finished. But 6th I have said 6th and 12th these are two what dates will also 14th 13th ठीक oblige
Item 10, WPS 1884 of 2020.
Yes. Should the matter be passed over for few cases as my senior Mr. Manish Tandon is on very severe application.
तासो
Item 12, CLP 632 of 2022.
Your Ladyship, instant petition has been filed for the restoration of WPS number 2457/2020, which has been stood dismissed on 7th June 2022 on the non-compliance of the preemptive order. Your Ladyship, the court fee has already been paid on the last compliance date. However, the few minor defects are there, like type copies still exist. So, time may kindly be granted to remove the same.
any objection madam? CLP number 632 of 2022. Counsel for the parties are present. This petition has been filed for restoration of WPS number 2457 of 2020, which stood dismissed due to non-removal of defects in terms of order dated 2/5/2022. Counsel for the petition submits that the petition be restored and he undertakes to remove the surviving defects within a stipulated time frame. Counsel for the state has no objection to the prayer.
Counsel for the LIC petition.
Counsel for the LIC has no objection to the prayer for restoration. Considering the aforesaid submissions, the writ petition being WPS number 24, the time granted to remove the defects in WPS number 2457 of 2020 is extended till 13th of December. If the defects are in the petition are removed within the extended time, office is directed to place the petition before appropriate court as proposed. It is still preemptive.
Obliged.
CMP
Item 19, Criminal Appeal 36 of 2024.
There is for grant of bail. Earlier, on last occasion, your ladyship, state was directed to inform about the present status of trial.
What is the present status? What is the present status?
Your ladyship, all the witnesses have been examined. The case is pending for arguments. That is came in the order sheet as well.
So it is still pending for argument.
Arguments, your ladyship. But last rejection was of 16/5/2023. 6 months time was given to conclude the trial, but till date the trial has not been concluded, your ladyship. Other co-accused have been granted bail. I have annexed the order.
But it is at the final,
Yes,
at the
Your
back
Ladyship.
end.
Yes.
We will not release. We can't.
He is in custody since 2021.
It is absolute at the final argument stage.
Yes.
The judgment will be pronounced very soon. Okay. Criminal appeal, civil debt, 36 of 2024. Counsel for the petitioner is present. Appellant is present, nobody appears on behalf of the opposite parties. Counsel for the appellant has submitted that. Where is my earlier order of rejection?
Your ladyship. Annexure 2, page 24, 25, 26.
Has
2 times rejected.
referred to annexure 2, which is an order passed in criminal appeal SJ number 464 of 2022, and also annexure
Annexure 3. Annexure 3.
Annexure 3, which is an order passed in criminal appeal civil judge number 710 of 2019 dated 24/9/2019. Wherein the wherein the criminal appeals were dismissed by this court, the counsel for the petitioner appellant has submitted that as per his instruction, the case is at the stage of final argument. He has submitted that one co-accused, namely Shiv Yadav, has been directed to be enlarged on bail by order dated 27 September 2022, passed in criminal appeal civil judge number 446 of 2022. After hearing the counsel for the appellant, this court finds that the prayer for bail of the applicant was rejected by this court by two orders as contained in Annexure 2 and 3. Considering the seriousness of allegation against the appellant, the fact remains that the trial is at the fag end in as much as the case before the learned court is at the fag end and it is at the stage of final arguments. This court finds that while refusing grant of bail by impugn order dated 7/12/2023, the learned court had considered the fact that the trial was in advanced stage and the learned court had referred to the evidences adduced from the side of the prosecution and refused to grant bail. Considering the totality of facts and circumstances and the fact that the trial is at the fag end, this court finds no reason to interfere with the impugn order dated 7/12/2023, whereby the application for bail of the petitioner has been rejected. Accordingly, this criminal appeal is hereby dismissed.
Leadership direction will be given to
Argument stage में
after
Yeah,
time
direction.
of the leadership. That is why I was saying. Maybe the court is in session, but the matters are not being taken up as per my instruction. I was only playing direction.
Since the matter is reported to be at the stage of final hearing, at the stage of final argument, the concerned court shall take all measure for expeditious disposal of the trials.
Yes.
And the parties shall not seek unnecessary adjournments. Is the question
Item 22 from daily list of court number 7. Contents will 359 of 2023.
एक मैटर है डिस्ट्रिक्ट
Lawsuit suppose has been filed on behalf of OP number 5 lawsuit. And they are also taking steps for compliance lawsuit. Page number 17, Annexure B of my suppose affidavit.
district account officer
Lawsuit.
या फाइल शो पास
Lawsuit. It is on record and page number 17 is the relevant part also.
just a moment. Content case civil number 359 of 2023. The matter has been mentioned before this court as the concerned court is not available today. The concerned court dealing with this case as per roster is not available today. MS, give her details. Is present in the court. The learned counsel for the opposite party has submitted that the show cause has been filed on behalf of the district account officer. Having recorded, this matter was mentioned only for the purposes to record her appearance before this court. let this matter be posted on next Friday. She'll come again. Let this matter be posted on next Friday before appropriate bench. The concerned officer shall remain present before the court on that.
From daily list item 22, CMP 434 of 2024.
Yes. What is this?
State CMP on disposal of WTC number 3702 of 2017, which has been dismissed due to non-compliance of order by law. पेज नंबर 12 है CMP का एक्स्ट्रा वन लगाए हुए थे, इसमें छोटा-छोटा डिफेक्ट था।
क्या बताइए पेज 12 में क्या बोलना है, क्या एरर है?
एक्स्ट्रा भाई जो डिफेक्ट था उसको हम रिमूव नहीं कर पाए थे, इसी के चलते पेनल्टी ऑर्डर था डिसमिस हो गया था, उसको हम 4 मिनट का टाइम दिए हैं, उस सब उसको और एक चिट्ठी था जो मिल नहीं रहा था, उसी की वजह से हुआ था। एक एक्स्ट्रा लगा दिए थे, नहीं मिल पा रहा, चिट्ठी RTI फाइल किए तब भी उपलब्ध नहीं है, तो उसको उस लिस्ट में हम उसको डिलीट कर देंगे, क्लियर कर देंगे।
CMP number 434 of 2024. This petition has been filed for restoration of WPC number 3702 of 2017, which was dismissed on account of non-removal of defects by virtue of order dated 19th of September 2022. This is for restoration of 3702 of 2017. The learned counsel submits that. The learned counsel for the petitioner submits that on account of non-availability of certain documents, the defects could not be removed. He is otherwise ready to remove the defects, and in case he is unable to remove the defects, he shall file appropriate petition before the appropriate petition for ignoring such defect. कुछ ऐसा करना है आपको, इग्नोर करवाना है?
हाँ, एक्स्ट्रा था उसको नहीं कर पाए।
He has also submitted that he may not rely upon a few pages of the writ petition, and
पैराग्राफ 13 था, इसमें जब स्टेटमेंट देके एक्स्ट्रा लगाए हैं पेपर में
आपको सबमिट
जी
करना है।
तो रीच में दिखा है।
आप आइए फाइल कर लीजिए। The learned counsel submits that the writ petition be restored to its original. Counsel for the state has no serious objection to the prayer for restoration. Correct?
There is 2 years delay, Malus, in filing this
The
restoration.
learned counsel, counsel for the state has submitted that there has been delay of 2 years in filing the petition for restoration. But at the same time, it is not in dispute that the present restoration is of writ petition, and the restoration application for restoration itself has been filed under Article 226 of the Constitution. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is inclined to restore the writ petition being WPC number 3702 of 2017 to its original file. It will be open to the petitioner to remove the surviving defects or file appropriate petition for ignoring any one or the other defects in the writ petition. The needful be done by the petitioner in the writ petition by 13th of December. 20 दिसंबर 4 वीक हो गया ना?
22 दिसंबर को हो जाएगा, उसके बाद फिर छुट्टी होता है विंटर वैकेशन, तो हम जनवरी फर्स्ट वीक में कर देंगे। अगर देर भी हुआ तो 4 वीक में पास
by 3rd of January.
हाँ ठीक ठीक से तो कुछ खोलेगा ही
CAG
5th
number
जनवरी पेंडिंग कर
434 of 2024 is according to this post. अगर एक बार भी और डेट मांगे ना
नहीं,
तो
कोई डेट
50,000 रुपये का कॉस्ट
कोई
लगा
डेट
देंगे।
नहीं
तो बस हो गया ना,
हम फाइल भी नहीं किए थे इसमें
बहुत अच्छी बात है। जहाँ सवाल पूछे तो हम फाइल नहीं लेते।
Item 28, WPL 680 of 2024.
Petitioner,
Your Ladyship, in serial number 28, it may be kept for final disposal, Your Ladyship. Date may be fixed.
तो आधी है फाइनल डिस्पोजल के लिए बहस करें। अलग से हेडिंग का चेंज करके क्या ही होने वाला है?
I am not ready.
तो ऐसा बोलिए नॉट रेडी, हेडिंग चेंज करने के लिए मत बोलिए। Why are you not ready?
I have not gone through the brief, Your Ladyship. I was informed from the opposite party, Your Ladyship, that he will not be present today, Your Ladyship.
How many matters are there? One matter.
Yes, Your Ladyship.
ये गुजरात केस में क्या हुआ? LPA 1009 और 2022. What happened in that case?
I have not gone through the brief, Your Ladyship.
Casually you say this.
One indulgence may kindly be granted, Your Ladyship.
Indulgence I'll give you. You pay cost.
Your Ladyship, then it may be kindly passed over for few cases, Your Ladyship. Just for my senior, Your Ladyship.
सीनियर आपको खाली यहाँ पे टाइम देने के लिए भेजते हैं। Yes. You never prayed for a Passover division.
It's the first time I tried, Your Ladyship. You are not well versed with the EPFO Act, Your Ladyship.
Sorry?
I am not well versed with the EPFO Act, Your Ladyship.
You are not well versed with the facts. You are not well versed with the act. So what is the difference between you and your clerk? Is there any difference? Okay.
Extremely
You have the
sorry.
file?
Extremely sorry.
Do you have the file?
Yes, Your Ladyship.
Show me.
Yes, yeah.
Show me the file. Read page number 105. पढ़िए 105 खोलिए.
Yes, Your Ladyship. The learned advocate has considered on behalf of appellant has assumed the
कम से
following.
कम फाइल तो है ये कंफर्म.
Yes, Your Ladyship.
Yes.
But
आप लोग दोनों एक जॉइंट वेंचर बना के रात को चेंबर में बात कर लेते हैं कि टाइम लेना है. ये सही बात है. Fair to the court. You will talk amongst yourself that you will take time. He says that you have been informed that you don't want to do the business. Take your break. ये सब तो इशू डिसाइड हो गया ना? नहीं डिसाइड.
did we raise the preliminary objection?
You.
Yes, that whether it is maintainable at the behest of the EPFO, the same authority has challenged the order. We had referred to Gujarat High Court decision there to file a reply.
क्या हुआ गुजरात हाई कोर्ट में?
In Gujarat High Court, similar case, rulership EPFO.
So what happened in LPA? LPA was 1009 of 22.
This is the order.
LPA order?
LPA.
Read order.
It is the LPA order.
LPA has been dismissed.
LPA was dismissed.
You have no locus. Listen.
Date may be kindly be fixed in addition. One and others may be granted in addition.
Why don't they have any locus?
It's the same authority in the even in the writ petition they have not mentioned that it is the decision of the board. Barely mentioning in the cost title Central Board of Trustees and the same authority which had passed the 7A order, which has been set aside by the appellate tribunal, is again being challenged by the authority who passed, and therefore the adjudicating authority, he cannot have any personal interest in his own order. In that decision, a Supreme Court decision was also relied upon. In Director ED case, Supreme Court, in which it was said that the director cannot file an appeal himself if his order is set aside by the tribunal of the court.
He was a director of?
In this case, it was a case of Directorate Enforcement Lordship.
That is a separate thing altogether. You see, these organizations are there to protect the interest of the workmen. ED is not there to protect the interest of any workman. ED is the prosecuting agency or maybe investigating agency.
No, but the only ground is that they should at least mention that the board has taken a decision.
That is a separate thing.
Because
that is whether the case has been filed after due authorization by the board or not.
Yes, but otherwise it becomes the personal interest of the officer that because my order was set aside, therefore I'll challenge it.
And then he files a case in the name of Central Board of Trustees.
Yes.
Is he a officer of Central Board of
No,
Trustees?
he is not an officer. And there is no authorization on record that he was authorized. Therefore, he was asked to give a written clarification.
क्योंकि अभी तो आप समझेंगे नहीं और अगला दिन भी यही कहानी करिएगा. There he is. Mr. Pati, there is an objection that this repetition is not maintainable at the behest of by naming the petitioner as Central Board of Trustees. Who are you? Who is the person who is filing this case? The adjudicating authority.
I'm sorry.
The authority who has passed the order of adjudication 7A.
Say Central Board of Trustees which has filed it, not
So,
the regional owned province.
No, let us see that. No, you see, if the Central Board of Trustees is filing it, where is the resolution? There has to be a resolution of the board to challenge this order. Where is it? The Wakalatnama also does not reflect.
There will be a delegation of power.
We do not know you satisfy this court because Wakalatnama is not reflecting that you are filing this case on behalf of.
Represented through the officer. Represented through the regional provincial commission.
You see, you are filing this case on behalf of Central Board of Trustees, Employees Provident Fund Organization. Are you an employee of this organization? No.
But they are under the administrative control of the board.
That's right. It's a separate entity by itself. It has its own seal and own decision-making process. So find out that there could be a delegation of power. Where is the decision of the board? Bring it on record. Unless that decision is there on record. Suppose we pass an order of cost. Let's assume 1 lakh rupees. Will the Central Board of Trustees pay that? They'll disown the requisition. They said we never instructed anybody to file the requisition. You file the resolution and you satisfy that it is a decision of the Central Board of Trustees to challenge the entity. There has to be that. You will file an affidavit or you will address straight up?
If some document is to be brought, then I'll bring it on.
You have seen the judgment of Gujarat. That is on a different line.
Yes.
But still, you need to address that also. You file an affidavit, you better file an affidavit.
Yes, madam.
Because there may be so many nuances to this.
Wide ramifications also, affidavit will be.
Affidavit would be required, and Gujarat High Court refers to 2 other judgments. One is Kerala High Court, other is Kolkata High Court. You file those judgments also.
Basing upon the judgment of Honorable Supreme Court, which was go under the PMLA Act, where
The contours are totally different because this Central Board of Trustees is not prosecuting anybody. They are basically representing the employees as a whole. So I do not know whether this angle has been considered by the Honorable Gujarat High Court or maybe by the Honorable Supreme Court. We will see those judgments. Because you see, who are the beneficiaries of Provident Fund? Even if the employees are not traceable, then also the employer is bound to remit the amount. And it is not one-to-one basis, right? It is a fund which is created and it takes care of all the employees. Therefore, it is basically an organization which is representing the interest of the workmen as a whole. So every recovery it goes to the kitty, isn't it? So I do not know. What will you say to this? ED case, I think, slightly.
No, ED was on the basis that the adjudicating authority himself challenged it. That was the case which has been.
Here also it is the adjudicating authority. Same person has passed the order, 7
He is representing the board.
But there is not even a statement
So
in the
there has to be
petition.
some authorization by the board to challenge it.
Under some delegation, under which delegation, what delegation is happening, that I will have.
WPL number 680 of 2024. Counsel for the parties are present. The learned counsel for the respondent has raised an objection that for all practical purposes, the writ petition has been filed by the adjudicating authority who had passed the order under section 7 capital A of the Employees Provident Fund and Miscellaneous Provisions Act 1952. Though the writ petition has been filed in the name of Central Board of Trustees of Employees Provident Fund Organization, he submits that no letter of authorization or no decision of the Board of Trustees has been placed on record to show that the writ petition has been filed at their instance. He has produced a copy of the judgment passed by Gujarat High Court in APA number 1009 of 2022 to submit that the adjudicating authority is not permitted to challenge the order passed by the tribunal. Tribunal has passed the order?
Yes. Tribunal has passed.
By the tribunal. The learned counsel for the petitioner seeks adjournment to file a supplementary affidavit to explain the circumstances under which circumstances and the authority under which the present writ petition has been filed, and also by referring to the judgment passed by Honorable Gujarat. LPA number 1009 of 2020. कितना टाइम लगाएंगे?
3 weeks. Because I may have to consult the board as well before filing, because this will have a effect on all pending litigation.
If the Central Board of Trustee has taken a decision to file the present case, the resolution of the board be also placed on record.
Delegate will also be included if there is some delegation.
You have to say that there is a delegation. You bring the delegation on record.
Yes.
Post on 10 January. किस लिए आप इतना लड़ रहे हैं? 7 है. क्या किए?
Only one person. The period of service is in dispute. Newspaper establishment is saying that I work for some extra period for which I did not have appointment letter. That has been decided, I guess, because the gratuity authority has also decided that it is from the date of appointment letter. Only that is the issue.
Item 30 CMP 886 of 2024. Item 30.
On behalf of Mr. Sanjay Prasad,
Mr. Sanjay Kumar नाम है. Mr. Sanjay Kumar, advocate, seeks adjournment and submits that Mr. Sanjay Prasad is not available to argue this case.
restoration
Post on 10th January.
restoration के लिए था इसको.
दोनों चीज नहीं चल सकती.
Item 31 CMP 894 of 2024.
Petition for restoration number 295 of 2023. Points regarding defects of court fees of ₹100, which was not removed.
CMP number 894 of 2024. This petition has been filed for restoration of MA number 295 of 2023, which stood dismissed on account of non-removal of defects in terms of order dated 31/7/2024. The learned counsel for the petitioner has submitted that only one defect, that due to inadvertence, the court fees could not be deposited. Suggest that the case be restored to its original file. Considering the submissions, the time for removal of defect granted by the order dated 31st July 2024 in MA number 295 of 2023 is extended till 6th of December 24. If the defects are removed within the extended time, office is directed to post the miscellaneous application before appropriate bench as per roster. CLP number 894 of 24 is accordingly displayed.
Item 23 CMP 911 of 2024.
So in this case also few pages, type pages could not be filed within time.
This is repetition.
Yes.
WPS number?
WPS number 7256 of 2023.
Same order कर दीजिए. 13 तक extend कर देना. Any objection? No. By 13. Right? So the council for the state has no serious objection with.
Now for the
prayer
JPS.
for
JPS.
Now for the JPS.
council for the opposite party JPS has no serious objection to the prayer for restoration. The council for the state and the university are absent.
Item 44 Criminal 1035 of 2024.
Yes, petitioner. Nobody appears on behalf of the petitioner. Pose this case on 6th of December. 6th day 13th.
Yes. CL 44. My lord, it's a tied up matter, my lord. Earlier rejection order is at page number 29. Only if I am here only if your lordship will kindly have page number 29 for a moment. Paragraph 5.
29.
Yes. Page number 29 is the earlier my lord's order. In paragraph 5. My lord, this case is of juvenile bail under section 302-201 of the Indian Penal Code, my lord. I am in custody since more than
302
201 of the Indian Penal Code.
Your custody is
18/3/23. Major co-accused have been granted bail by this honorable court, who were major in age. My lord, may I take your lordship's kind attention to paragraph 5 of page number 29, which is annexure 3, the lordship's order, my lord.
Yes.
But your lordship's observation in paragraph 5 and the major ground for rejecting the bail back then on 1st August 2024 was that on the basis of confession statement, the recoveries were made of the articles said to have been used in the murder of the deceased. This is the observation of this honorable. My lord, I most humbly state that I have stated this on affidavit also, and in my most humble submission, my lord.
Where is it mentioned that on account of
Yes, page number 30, line 2.
29?
Yes, continuing page number 30, second line.
Yes, please.
On the basis of confessional statement, recoveries were made of of the articles that have been used in the murder of the deceased. This is the judicial observation by this Honorable Court while dismissing the previous application.
Yes.
Yes. But in my most humble submission, I have stated in my affidavit also, and I have cross-verified with the case diary as well. I was under the guidance that we could not go and mention the matter after it has been disposed of. That's why I did not mention it then. But my arresting has been done after the recovery of the murder weapon. So my arresting has been done at around 8 p.m. My confession statement has been recording at around 10 p.m. The recovery of the murder weapon was made at 4 p.m. by some other co-accused confession statement, my lord.
Sorry, your
Arrest.
arrest is?
My arrest is on 17/3/2023, 1950, 7:50 in the.
You see, if there is any error in this order,
Yes.
we can't review this. Can we?
So this was the sole of my lord. I am only praying for your lordship.
See, once the order is passed on merit in a criminal matter, there is no question of any review. There could be a subsequent development. Or if you were aggrieved by this order, you ought to have challenged it before the Supreme Court.
Before this one,
Yes.
because this petitioner couldn't have assailed this order to the Supreme Court. That's why he has.
Why not?
My lord, through legal aid, if he had gone, my lord, it would have taken 6 months. Yes.
Legal aid is very robust. It will take 6 months.
My
Who
lord,
said?
And
as it is, it was rejected when?
1 August 2023, 2024, my lord, I'm sorry. But my lord, we chose to come before this honorable because this was.
You see, we can't sit in review to our own
But my lord, now on merits only, my lord, I have challenged this order once again. My lord, it is clear cut. As per Section 12, insofar as my limited experience is concerned, my lord, Section 12 says any known criminals, my lord, he has in the social investigation.
Don't shift from one point to another.
Yes, so only insofar as this point is concerned, my lord. My bail rejection was done on a point that there is a recovery of the murder weapon from my confession.
And parasites is not important. Your social
Yes,
investigation report
that
is
is
not
what
important.
I was coming. I'm coming to that also.
That is the second point. So far as this point is concerned, we are not going to sit in review.
Which point, my lord? This recovery point.
No, we will not sit in review.
My lord, in my most humble submission, all the humility at my command, my lord, at this stage, my lord, this is my lord, error on. I may say that I could have also shown, but I did not have the case diary. Today also I don't have the case diary, but I have checked with the case diary, my lord. My lord, this is unnecessary harassment to one juvenile because, my lord, his confession, my lord, the recovery has not been made. He was arrested much after the recovery was made, and the recovery was made on somebody else's confession who has already been granted bail by this honorable court, my lord. Only if your lordship may kindly consider, I am only praying that case diary may be called for, and thereafter, my lord, may kindly, as per your lordship's.
What is the stage of inquiry? What is the present stage of the case?
Lord, for that I have to take instructions. I'll
You
take
don't have
it.
any. You have material
My
instructions.
lord, children court, the case is going for the trial is, my lord, concluded in the not concluded, but the trial is going on. Children court.
What is the stage?
My lord, I'll take an instruction, or my lord, this stage may be called for, my lord, and my lord, diary may be called for because, my lord, this is insofar as my limited experience is concerned, my lord, this juvenile is lying in, my lord, custody for last more than 1.5 years, my lord. And ground of
Submission was also made on behalf of the state that the articles were recovered on the confession statement of the petition.
That is not a part of the record, my lord. May kindly call for the record for a moment. It will take 1 week, 2 weeks, whatsoever, my lord. Is only for lordship may deem fit. And of course, subject to your lordship's kind consideration, my lord. Case diary may be called for, my lord. Because this court is for, my lord, securing the ends of justice in my most humble submission, my lord.
What is this order? Next page. The judgment.
Juvenile justice, the appeal judgment, right?
Yes.
The district judgment. But the social investigation report also says bad association, not known criminals. That was my case, my lord. So only this point may be considered. My lord, I had no intention. The case diary says my CDR was not there. The co-accused whose CDR was there, he has been granted bail by this honorable court, my lord.
You see, the case of
A major
stands on a different.
Yes, my lord, I got on.
You cannot compare a juvenile case with that of
As your lordship pleases, my lord.
In which juvenile home are you there?
My lord, Jamshedpur, my lord,
You are also beyond the control of your parents.
it's now been almost not 2 years, but my lord, almost 2 years. So, my lord, things may have changed
Is the purpose of social investigation report, Mr.
to better.
It is called only to see that he doesn't fall into the bad company again. It suggests that he is not in a good company, in bad association, as you mentioned. So,
What is the present stage of the case? And you are to be tried as an adult.
Lord, my children court, my trial will run.
So, where is that report? Because
That report was called for by this honorable court in criminal revision number 173 of 2024, my lords. That was already called for, and that was perused by lordships, my lord. I've stated this on affidavit, my lord, so only if a lordship may deem fit, my lord. I'm only praying.
this was rejected way back in 1 year back. What is the present stage of the trial?
The report may be called for along
You
with the
see,
case.
we are not going to review our own orders.
My
We
lord,
can only consider the stage.
I am only praying that the report and along with the case diary, so that this honorable court, my lord, may only if your lordship may deem fit and appropriate, subject to lordship's kind approval, may kindly see that whatever submission that I have made and what is on affidavit is, my lord, correct or not. Because, my lord, I have taken down from this honorable court's diary, my lord, and that there was no. I had stated also while the time of my argument, but due to some circumstances, my lord, it couldn't be recorded, and my lord.
Please don't say that.
Yeah.
ये अच्छा है आजकल YouTube चलता है.
Yes. Lord,
You say that you also submitted and it was not recorded in the order.
my lord, I submitted this.
You say that it is not recorded in the order.
Not, my lord, contrary to which, my lord,
No, I just let me understand. You say that you submitted this and it is not recorded in the order. How serious it can be?
My lord, I submitted that there was no recovery. This I have also checked. So far as because this is an error could be on my part also, my lord.
We are not going to review our own orders on this kind of assumption.
No, my lord, I'll take my word that that was not.
Please don't take your words back.
No, it is not intentional, my lord. I'm not saying something.
It is absolutely intentional. What is this? You say that in an order you said something and it is not recorded. It is something very serious. For you may say whatever very lightly.
No, I'm saying that, my lord, the recoveries were not made from my confession. That was submitted, my lord. It was state submission that the state submitted that the confessions were made. I, my lord, stated that it was not from my confession, my lord, and which is a record I am saying. It is nothing, my lord. Of course, my lord, I cannot dare to say something for this honorable court, which is, my lord, inappropriate. If your lordship tells something, I of course go down, my lord.
We will not take all this from you, right? And it is quite a
limited experience before this court.
It is quite a serious offence. It's a heinous offence.
Lord, but he has a right to be tried, my lord.
What do you mean, right to be tried? What is the maximum punishment that can be awarded to you? Then?
Well, the report
You are facing a trial for life. You are between 16 to 18 years and you understand the intricacies of a crime.
No, but I have reasons to believe that I have a good case, my lord, and
You
I
may
cannot
have a good case. Expedite your trial. Expedite your trial.
Lord, conviction and reason being, my lord, he has been unnecessarily, my lord, being because only if your lordship may kindly, because, my lord, I had no intention, my lord.
You find out, no, we are not going to call for case diary and all.
My lord, report may be called for at least, my lord.
No, nothing.
Let me take a chance only if your lordship may deem fit.
There is no question of it. We can just find out the stage of the trial.
My lord, yes. I will take instruction on this point. So maybe post it next week only if your lordship.
Criminal Division 1035 of 2024. office is directed to call for a report in connection with the present stage of the trial. Relating to Sincora PS case number 36 of 2023 from the Court of London Principal Magistrate Juvenile Justice Board, Jamshedpur.
Yes, madam.
This in before the Juvenile Justice Board yet?
Lord, on the last the children court.
It has been transferred to Children Court.
Yes. That has been recorded in Lordship's order also, Lord. Page number 29 of Lordship finding that.
The Learned Council has submitted that the case has been transferred to the Children's Court, concerned Children's Court for trial. Trial has commenced.
I have no instruction.
The council has no instructions as to whether the trial has commenced or not. Stage call for trial. Thank you. The report should also indicate the time likely to be taken by the concerned court to conclude the trial. Post on 13th of December. Let this order be completed 3 months.
Lastly, if I may submit that I had just argued for my claim and I had no intention to do this.
Nobody in this court can
Yes.
say,
Never.
at least for this court,
Maybe
that
I got
they made a submission and it was not recorded.
Lord, maybe, and of course I can
Even
never
for
dare
an
to.
adjournment order, I record your submissions.
Yes.
There is no such order like simpliciter adjourn. Have you
Never.
seen such order of this court?
Never.
Simpliciter adjourn?
Lord, I can never dare to, Lord, I tender an unconditional apology only for Lordship felt it otherwise. I had no intention, I can never dare to have a career to pursue before this honorable
No,
court.
you don't need to be.
We have to guide it.
We are not here to
We have to learn from
corner
the
you for
Lordship.
anything. But whenever there is an order passed, you can't say that I argued this and it has not been recorded. This is bizarre.
No, every day we have to learn, my Lord. We learn from our Lordships, my Lord, every day. And I have no intention to, my Lord, make
And
any
if
sense.
you are agreed by an order,
I
you can challenge
Tested,
it.
of course, my Lord.
You should have challenged it.
We could have tested, but that was
You
not
have.
then.
You can't say that you are a poor person because we have robust legal aid system in Supreme Court. Very robust. You can't say it will take 6 months time. No. It will take maximum 15 days time.
But in this Jhalsa legal aid, we have like
You don't need to go to Jhalsa legal aid. You can straight away go to
Supreme Court.
Supreme Court legal aid. This legal aid is applicable. Is available. Very robust legal aid system in Supreme Court. As I understand, it can go straight away.
We've learned something new from this honorable court also, Lord. I have no intention, Lord.
Anyways, we don't take anything to our heart. But still, we don't like it when you say
I
that
just had to say this
that
when it is.
this was submitted and it was not recorded. Something very serious.
Item 45, BA 1187 of 2024.
Nobody appears on behalf of the petitioner. I did for the state. Counsel for the state is present. Close this case on 13th of December. On 20th December. This December.
Constable case item 10. Double case 1884 of 2020.
He's again gone.
Leadership Mr. Duncan has himself discussed.
Sorry? That's right. He's gone. Counsel for the petitioner seeks a judgment. Next week.
Leadership can it be kept after the next week, as next week Mr. Tandon is.
You can post it after vacation also. That would be better, let him be comfortable.
Leadership.
3rd of January.
Leadership.
Please.
Actually, next week there is this court is very that is why.
Yes, I know that. That is why I am just, we will be otherwise keeping busy. So we are just posting it on 3rd of January. We'll do it on that day. Is there any objection to that?
For hearing item 70, WPC 548 of 2005.
डिस्पोजल हो गया
Where is the petitioner? So will you be forward? Where are the parties? Nobody appears on behalf of the parties. The case has been listed after the final order passed by this court was recalled by order dated 13/6/2024 passed in civil review number 11 of 2020. Post this case in the supplementary causes from Tuesday.
Item 71, WPS 5332 of 2010.
Nobody appears on behalf of the parties. With the view to give one more chance. This case?
नहीं इसके पहले 71 चल रहा
Pose this case under the heading of final disposal on seventh of January.
Serial number 70, earlier we were conducting litigation on behalf of the respondent's mediation, but after the order was passed, the clients have taken the file from us. And now the same has been taken over.
I have just given a date. You come on that date to inform the school. We'll issue notice.
So
Some
this
of them have already expired, it seems.
26 no.
It is primarily for the petitioner to come and argue the case. Who filed an application for review?
That was they.
Petitioners only had filed the application for review. After getting the order recalled, now they don't want to argue the case.
Item 72, WPS 5374 of 2010.
कौन सा इसके previous validity
Same order, but same order. Nobody appears with the same order.
for final.
Is it listed?
One kind of urgency of the lordship. The trial of this, I got the instruction of trial pending. So if that line may be redacted only for lordship, may fit that. I have no instructions. It's an evidence stage.
I do not know. I've already dictated the order and
As you
you
wish.
see.
As you
At
wish.
that point of time, you did not have any instruction. You come on the next day.
As you
And
wish.
by that time, the report will also come.
Yes, I'm